Hello everyone, my name is Mike Gilligan, and here is part 3 of my temporary order of protection. I'm doing this for myself as therapy, and I'm also looking to inform people and maybe show them how I attack this temporary order of protection, and maybe they'll find a way to help themselves if they find themselves in my shoes and in their situation. Um, Part 3, we're going to go right to the arraignment. Now, what I've done is I've pulled up a definition of arraignment here on the internet. Now, arraignment, a criminal proceeding in which the defendant is officially called before a court of competent jurisdiction, informed of the offense charged in the complaint, information, indictment, or other charging document, and asked to enter a plea of guilty, not guilty, or as otherwise permitted by law. Depending upon the jurisdiction, arraignment may also be the proceeding at which the court determines whether to set bail for the defendant or release the defendant on his or her own recognizance. This is a family court matter. The arraignment is a formality. On September 20th, 2016, I appeared in Suffolk County Family Court before a judge named Jeffrey Spinner. The minute I was called into the room, my ex was called in at the same time. They actually had us standing next to each other. So much for the protection. Court officers were, I was closer to my ex than any court officer was. But right away, when I entered the room, and I had been observing what was going on in court, and he had been conducting business as usual, and basically people were coming in ex parte and asking for orders of protection, and a lot of ladies were going in, and a lot of ladies were coming out smiling. So basically, he's giving these orders of protection out to folks like crazy. I didn't see any men come in there with asking for orders of protection against a female or somebody else or significant other, but this is what's going on. Excuse me. But as soon as I get called in, we go before the judge, and he's pretty much got his head down, and he's, I'm the next piece of meat in the assembly line, and he was mumbling, and he said something. I can recall him saying something about, due to the nature of this family offense petition, the court is going to enter a plea for Mr. Gilligan of not guilty. And I piped in right away. It says, "Excuse me, you're pleading to what? What do I need to plead to? I don't feel the need to plead to anything." And right away, because I interrupted him, he looked up at me in his superior way with his eyes over his glasses and saying that, Mr. Gilligan, you need to speak to an attorney. And I says, I don't wish to speak to an attorney. I don't need to speak to an attorney because, this complaint doesn't articulate a crime or a family offense. And right away, and then I went further and said, I don't consent to the benefit of the court, and I don't wish to be here. I'm under duress, and I don't understand what's going on. And this is what you need to say. You know what I mean? If I was to do it over, in a different way, I'd be like, I'd have a script ready. You know what I mean? You basically got to tell the court you don't understand. And at an arraignment, you need to meaningfully and knowingly understand what's going on. And the fact that I got some of those words on the record caused him a problem. You know what I mean? When I told him I didn't consent to the benefit of the court, it was kind of funny because he looked up at me and said, "Mr. Gilligan, your consent is not necessary." I said, "Oh, really?" And basically, he went on with the proceeding. You know what I mean? And again, kept warning me, kept saying to me that I should get an attorney. It's advisable to get an attorney, and basically telling me I don't know what I'm talking about. Because he's God on the bench, and He basically went. The next thing he did was he assigned a law guardian to my sons, and I already had a case in Supreme Court going on at the same time, and they carried over the law guardian from that, a woman by the name of Teresa Mary, who another person I have no use for, and doesn't really represent my kids properly, and I objected to that, and but Dad went on deaf ears that they were going to do it anyway, for their own purposes. And the whole idea, in my opinion, is that the court needs to use me in this situation to help other bar member attorneys make some money. And in family court, law guardians get paid by the state. The litigants don't get involved in paying the law guardian. So Jeffrey Spinner helps out one of his bar member friends, and helps them make some cash. But he ultimately refers the matter to conference and for a date in October. But what I want to go over here is that the one thing this judge didn't do from the get-go is he never issued me any Miranda warning. He never told me that I had the right to remain silent, to refuse to answer any questions. And that may be a formality in a civil arena in a family court, but I still think it's necessary. He needs to advise me of my rights and the fact that whether or not I do want an attorney or I don't, and officially state it on the record. The next thing, the most important thing here that he didn't do, was that he never states a cause of action or a family offense, which is basically either a violation, misdemeanor, or a felony, a crime, and never tells me what it is. And as we said and when I said before, in this definition here, the court of competent jurisdiction informed of the offense charged in the complaint, information, indictment, or other charging document. The offense is never stated to me, not once. He never tells me what it is. He doesn't say it's harassment. He doesn't say it's stalking, because that's what she indicates it is, stalking and trespass. He never states what it is to me. He just refers the matter to conference. This is business that he's conducting, and he's using me and he's using the ex-wife and her high conflict bullshit offense petition to try to make some money off me. And I'm not having it. You know what I mean? I clearly stated I don't understand what's going on. I didn't want to plea. I objected to him pleading on my behalf. And the other thing he does is, like I said, by entering the plea, he's practicing law from the bench. He never directly asks me, which is a problem. He should be telling me, do you wish to plead guilty or not guilty? And I may have applied a strategy, that's put forward by Mark Stevens. I don't know if you ever watched the No State Project. He basically says you come to court on the arraignment, and you have an unsigned notice of guilty, and you tell the court that, listen, you're thinking about pleading guilty. You're given this notice, which basically says, it's unsigned. You give it to him and says, I'm willing to sign this, but I have a few questions for the court. That's pretty much a good way to go about getting information out of the court. You know what I mean? It kind of stops them from their assembly line type process, by entering pleas for people and making this look somehow legitimate. And this is not a legitimate thing, and I have a right to know, and I have a right to see discovery and, to know, what I'm being charged with. The whole time I'm in court on this matter, I was never told specifically what the nature of the order of protection was. What's the basis for it? The cause of action, the charge. Nothing. I was never told. It's just a sham. It's just absolute sham. And you need to really understand. You have to understand, what your rights are. You have to understand what Miranda is. Look it up. And you have to understand that the court has a responsibility to say to me, somebody, that's coming before him, and this is a pretty serious matter, what is the charge? What's the nature of what I'm here for? And basically that's it. That's what happens. And the arraignment goes, it's pretty quick, but what I did immediately after this, now this is September 20th, 2016, after the arraignment, is that what I do is I file a motion to vacate um, the order of protection based on no subject matter jurisdiction. And here is a copy um, of the documents. Let's see what I got here. Here we go. This is it right here. This is actually Jeffrey Arlen Spinner's response to my paperwork I submitted. Let me get to that first. It was denied on the 26th. But this is what I filed with the family court under the docket, and I put myself down. A man aggrieved, the claimant, and the motion to vacate, challenge jurisdiction of court to enforce a temporary order of protection. And basically, I demand to vacate, challenge jurisdiction by clarification of evidence for court to enforce temporary order of protection, challenge jurisdiction of Teresa Mary, the law guardian, to represent the rights of my offspring, my two sons, who were listed on this order of protection, and they were never interviewed by the police. It's basically hearsay that they're allegedly scared. I could tell you this much: I spoke to my son since then, who's 15, and he just thought it was ridiculous. He said he wasn't scared, and it was ridiculous. And but here is my what I wrote. You could read it for yourself here. I'm going to go through it really slowly. You could pause it and read it for yourself. Here's the second page here. I indicate the Bill of Rights, the New York State Constitution, what my rights are, that we're entitled to a trial by jury. What else? Equal rights, equal protection under the law, discrimination and civil rights prohibited. And pretty much, here we go, Miranda again versus Arizona, having to be properly informed of your rights. And I had help with this. I have a good friend of mine. His name is Rick W. He has a YouTube channel. Very intelligent man, and helped me put this together. And I submitted it to the court, and almost immediately, it was denied. You know what I mean? And it's pretty well written. And like I said, you could stop and pause it at any time and read it for yourself. And I had it notarized. But let's go back to beginning where it's denied. It was denied on the 26th. I had submitted it on the 23rd. And in his response, he basically he puts me down. Where's the meat and potatoes of what he says in here? Respondent has filed the above described document with this court within he appears to demand omnibus relief, which relief is not in any wise articulated in a legal or factually cognizant manner. This guy's a dick. Basically, he's a dick. Even affording the respondent the benefit of ever favorable inference and resolving all questionable issues in his favor, the submission could mostly generously be described as a hereticking, ranting, and otherwise rambling diatribe which inter alia, I should look that up, I can't remember what it is, purports to invoke a constitutional right to a trial by jury. Jury trials have long unavailable in family court proceedings. Unavailable because it's not in the family court's best interest to do that. They made the decision to do that without the people's approval. And basically, if there were jury trials, or even a jury of 6 people in family court on specific matters, they wouldn't make any money because most of the stuff would be thrown out. because he can't conduct business the way he wants, Jeffrey Spinner, and he can't, hire services like law guardians, social workers, psychologists. He can't get other members of the Department of Social Services involved. This is all business. It's all about money, and so he denies it, and he denies it, and at the same time, like I said, he has never told me what the offense is that I'm there for. So, how is it that I'm still under this order of protection? And by the way, this order of protection, temporary order of protection, has no expiration date attached to it. Not one. Most of the ones that I saw when I was a cop in the NYPD, they had like a 90-day, temporary order of protection. This one had no expiration date. And I was curious about that. And, but, I believe this may have to do with the fact that I am a parental rights activist, and I'm involved with Americans for Legal Reform, which Jeffrey Spinner knows. He's asked to have lunch with the president of Americans for Legal Reform. As I was told, I was before him, but the bottom line is that this guy Jeffrey Spinner is. I don't know him personally, but he looked to me like the type of person who was, he's the kid during in school that got his lunch money taken from him every day, and now he's getting back at people on the bench because he can. But I don't know if that's the reason, but that's just when I look at him, that's what I think. He's got glasses, and he looks a little dorky, and and very intellectual. But the bottom line is that he's this is where my rights began to be violated. You know what I mean? And I've been now forcibly have to stay away from my children. And understand this: hiring an attorney and having them represent me, they would have never have done this. They never would have challenged jurisdiction, and that's it. And that's a problem. You know what I mean? Lawyers and members of the bar believe they have jurisdiction over us 24/7. They don't believe that they have to prove anything. And basically, you have to prove jurisdiction. It has to be a cause of action. It has to be a reason why this matter is being before the court. The court can hear the matter because, me and Mrs. Gilligan used to be married, and it falls under that definition. But there has to be evidence of some kind of action to bring it before the court. And he never articulates that to me, and it's clearly not in the reports. When two officers say no offense committed, come on. As a former policeman, it's definitely insulting to me, and this is what goes on. Bar member attorneys will not challenge the jurisdiction. They will not go in there and challenge it, because they'll get themselves in trouble with the judge, and they'll find themselves suspended or before a bar committee answering why that they're doing this, and they have to toe a line. And like I said, they believe they have jurisdiction all the time just because a statute says so. But just because a statute says so, it basically says it because certain courts hear certain things, but you still have to support the subject matter with evidence, and that was never done here in my case. But that's it for now. That's all I'll talk about in part 3. Again, take a close look at this. I'm sorry if I'm going by really quick, but you can see what I put in here. There was a lot of effort and time put into this, and I feel it was written very well, but he has to put me down because, again, I'm not a bar member attorney, and how dare I, challenge his the jurisdiction of the court? How dare I? And I did, and this is what you have to do, and you have to do this on your own because you're not going to find a lawyer to do this for you. But again, we'll have part 4. We'll continue further. Have a good day.